Hart, Fuller, and the immorality of law. H.L.A. Hart, the outstanding British legal theorist of the 20th century, wrote an accessible book outlining his version of legal positivism called The Concept of Law. The ostensible task of the concept of law was to help law students get their thinking about law as a concept clear, to show them what we really mean when we describe something as a law. Hart's big claim, which he didn't manage to hold on to consistently, and which subsequent generations of legal positivists have often wanted to qualify or abandon, is that although law in fact often reflects and contains moral judgments, there is no necessary connection between law and morality, either in terms of the content of law or in terms of the way that law is made. Legal positivists such as Hart worry that by saying that all law necessarily has a moral weight, natural law theory encourages the mistaken assumption that anything which is called law necessarily has an overriding moral weight, and therefore it leads to people being insufficiently critical of laws which are in fact deeply unjust. As Hart put it, however great the aura of majesty or authority which the official system may have, its demands must in the end be subjected to moral scrutiny. Natural lawyers worry that by setting questions about the morality of legal rules to one side, by putting those questions in a separate box, as it were, legal positivists both misdescribe law and make it easier for lawyers to become pure technicians who never take the time to ask themselves whether what they're spending their time doing actually contributes to the human good or in fact serves evil. As Fuller puts it, in its concern to assign the right labels to the things men do, legal positivism seems to lose all interest in asking whether men are actually doing the right things. After the Second World War, the debate about whether law had an inner morality so that certain moral values are always promoted if a regime governs according to law was conducted between H.L.A. Hart, the British legal positivist, and the American legal scholar Lon L. Fuller. The debate was focused around how to make sense of the way in which the Nazis had governed Germany and the territories which they conquered. Were the Nazis governing through law, and so their citizens and subjects faced a genuine moral dilemma about whether to disobey the law or not? That was H.L.A. Hart's position. Hart's position is easy to state. Under the Nazis, there was law, even if it was bad law, and that seems instinctively attractive. But Fuller argued instead that the way the Nazis governed was not through law, but was a violation and a perversion of law, so that the commands issued by the Nazis simply failed to count as law. They were orders issued by thugs and gunmen, not authoritative, presumptively binding commands. Now, in part, the disagreement between Hart and Fuller arises because each of them is focused on a different question. Hart is trying to define what law is as a concept. Fuller is trying to show how law works as a technique. Hart's focus is on language, semantics, and formal logic. Fuller is interested in trying to understand the benefits and mechanisms of legal order as a form of governance. Now, Hart attempts to give an imminent account of how laws can be rules which create obligations of obedience, though he's at pains to distinguish between a legal obligation to obey and a moral obligation to obey. In many cases, Hart thought that the legal obligation to obey and the moral obligation to obey would coincide in practice, but he did think there could be cases in which the legal obligation to obey existed, but not the moral obligation. So, for example, you're faced with a law that is extremely evil, and so what you should do is disobey it, morally speaking. The weakness in Hart's position exposed by Fuller is this. Hart wants to say the law surely is not the gunman situation writ large. To do this, Hart argues that a legal system is based on certain fundamentally accepted rules specifying the essential lawmaking procedures. We want to identify something as a law, we have to see that it's been made by the right source and in accordance with the legally authorized procedures. Now, Fuller argues that compliance with the procedural requirements for making law is required, save in exceptional cases, if the commands issued by the sovereign count as laws rather than orders issued by a gunman. Thus far, he appears to be in the same position as Hart. But Fuller argues that morality is connected to law not in one but in two ways. Fuller agrees with Hart that once you've identified whether something is law or not, there is an important question about whether it is a good law or not. But Fuller also insists that the procedural requirements for lawmaking are in fact moral requirements. The procedural requirements attached to lawmaking are good because when commands issued by authorities are issued in accordance with the procedures, citizens and subjects know where they stand. They know what the rules are, and they know how the rules will be applied to them, and therefore they can plan their lives accordingly. The reason why many of the commands issued by the Nazis were not law is, according to Fuller, because those law commands were not issued in compliance with the procedural morality, or what Fuller calls the inner morality of law. And he gives a series of examples. The Nazis issued secret laws, so people would be punished for breaking a law they could not have known about. Secret laws were also issued to legitimize the killings which occurred in the concentration and death camps. The Nazis issued retrospective laws so that people were punished for something which became illegal only after the person had committed the act. The Nazis applied laws by analogy so that people were convicted of crimes based on arguments that their actions were similar to something that the Nazis declared to be illegal. And when in 1934, more than 70 members of the Nazi Party were assassinated on Hitler's orders, he passed a retrospective law declaring that the killings were lawful executions. Most blatantly of all, in Kristallnacht, and whenever it suited their purposes, the Nazis would simply bypass the legal forms entirely and act through the parties in the street, terrorizing and victimizing. In short, Jews and others living under Nazi law never knew where they stood. They were not living, in fact, argues Fuller, under a legal system, but under a reign of terror. For Fuller, the heart of the rule of law is the idea that in acting on the citizen, a government will faithfully apply rules publicly and previously declared. He insisted if the rule of law does not mean this, it means nothing. And this conception of the rule of law was, he argued, sustained by a commitment to 8 principles of good rule-making, principles he described as the inner morality of law. And his 8 principles of the rule of law are that laws must be general, they must be promulgated, they must be prospective, they must be clear, they must not be contradictory, they must not be impossible to comply with, they must not be constantly changing, and they must be enforced by officials in ways that match what is written down. Fuller claimed that governing according to law required substantial commitment to these 8 principles, though in exceptional cases, one or more of those principles might be departed from. But when these 8 principles are generally obeyed, citizens and subjects know where they stand. When these 8 principles are generally disregarded by rulers, citizens and subjects enjoy no meaningful freedom. In Fuller's own words, when a system calling itself law is predicated upon a general disregard by judges of the terms of the laws they purport to enforce, when this system has been statutes, when the system has only to resort to forays of terror in the streets, which no one dares challenge, in order to escape even those scant restraints imposed by the pretense of legality, when all these things have become true of dictatorship, it is not hard to deny the name of law. Fuller's account is consistent with that of the 12th century Christian writer John of Salisbury. He argued that between a tyrant and a prince, there is this single or chief difference, that the latter obeys the law and rules the people by its dictates, accounting himself as but their servant. The difference between the tyrant and the prince is that the prince counts himself as bound by the law. Law is, for Fuller, a way in which power is disciplined and put to use to establish a framework in which people may flourish. Tyranny is governmental lawlessness. So Fuller stoutly defends the claim that his 8 principles are the inner morality of law, as distinct from the external morality of law, which concerns the ends which ought to be sought through legal rules. When he published a revised edition of the Morality of Law in 1969, Fuller added a 5th chapter, Reply to Critics. As he explained in a letter he wrote to Hart on the 6th of March 1969, the main accusation he was seeking to rebuff was that respect for the 8 principles of legality is merely a matter of efficacy. So simply in order to make law, in order for law to work, you need to follow these rules. There's no moral value in those procedural requirements in themselves. In that additional chapter, Bullock develops and extends his argument that lawmaking in line with his 8 principles is moral, is other regarding. He demonstrates by comparing law with a regime of managerial direction that the enterprise of governing by rules embodies a certain respect of persons as moral agents. Fuller thought the inner morality of law was a necessary, though not a sufficient, condition for the realization of justice. That the inner morality of law is violated when an attempt is made to express blind hatred through legal rules, and that the specific morality of law articulates and holds before us a view of human nature that is indispensable to law and morality alike. This view of human nature, which underpins law, is the view that human beings are or can become responsible agents, capable of understanding and following rules and answerable for their defaults. The novelty of Fuller's position is that he presents his inner morality of law as a kind of procedural natural law. Unlike traditional ideas of natural law, Fuller is not arguing that procedural morality of law is a higher law. Instead, he says it's like the natural laws of carpentry, like the rules that have to be obeyed if you're going to construct something, if you are a carpenter. Nonetheless, Fuller's assumptions about human flourishing and about the importance of freedom make best sense if understood in conjunction with a robust belief in substantive natural law.